Good morning, dear participants, and welcome to the second day of the Tokyo International Law Seminar. The first program for today is, as we announced yesterday, a lecture by Her Excellency Judge Tomoko AKANE, the President of the International Criminal Court, under the title Domestic Implementation of the Rome Statute and the Principle of Complementarity. Judge AKANE has been serving as President and Judge at the International Criminal Court, ICC, since 2018. Prior to joining the ICC, Judge AKANE has served for many years as Public Prosecutor of the Supreme Public Prosecutor's Office of Japan. Through her career as Public Prosecutor, Judge AKANE was involved in legal technical assistance and capacity building for legal and criminal justice practitioners, including prosecutors and judges from other countries. It is thus truly a privilege for us to welcome the President of the ICC to the Tokyo International Law Seminar. Once again, welcome Judge AKANE, and the floor is yours.
Thank you. Thank you, Mr. Ono. Good morning, dear participants and organizers of the Tokyo International Law Seminar. Ladies and gentlemen, it is a great pleasure for me to be here today at the second Tokyo International Law Seminar. I will deliver my lecture related to the International Criminal Court, the ICC, or the court in short, and one of the principles of the Rome Statute. Today's theme is domestic implementation of the Rome Statute and the principle of complementarity. The Rome Statute is the founding treaty of the ICC, as well as the first and highest applicable law when the ICC operates under it. I am originally from Japan, one of the Asian state parties to the Rome Statute. Before joining the ICC, I was a prosecutor in Japan for a long time. I am delighted to see so many practitioners and officials from different parts of the world, and the Japanese judge, as a Japanese judge at the ICC, to see some of you from Asian and African state parties to the Rome Statute. Some of them are not from the states which are the ICC members, but including non-state parties participants, I really welcome all of you to this forum. The Rome Statute currently has 124 signatories. I hope that this number will keep growing, and the fact that practitioners such as yourselves are interested in the court is always a good starting point. At the ICC, I am currently attached to the appeals chamber, but up to until my election as the ICC president 5 months ago, I worked mainly as a pretrial judge for 6 years. The topic of today's lecture is closely related to the work of pretrial chambers, as it is the pretrial chamber that carries out judicial oversight against the prosecutor's investigations in situations. The ICC is a permanent international criminal tribunal established in 2002, which deals with war crimes, crime against humanity, genocide, and the crime of aggression. These 4 categories of crimes are usually called core crimes. It is not the first international criminal tribunal, and as you know, there were 2 international military tribunals established after the Second World War, and several ad hoc and hybrid tribunals in the late 20th century. But the ICC is unique in the sense that it is permanent. Therefore, it is the only international criminal tribunal in history that was established to be always ready to prosecute criminals that may occur, prosecute crimes that may occur in the future, as opposed to others that were created to punish crimes that have already occurred. Compared to traditional international law, several areas of which will be covered by other lectures during this forum, international criminal law is relatively new field that emerged mainly after the Second World War. It is different in one important aspect. It presumes an obligation directly imposed on individuals as opposed to states. International criminal law is based on the idea that rules under international law regulating conduct during hostilities can only be effectively enforced by punishing individual criminal responsibility. As famously held by the Nuremberg Tribunal, quote, crimes against international law are committed by men, not by abstract entities. And only by punishing individuals who commit such crimes can the provisions of the international be enforced, unquote. The Nuremberg trials or Tokyo trials were hardly fair, especially when compared to proceedings before the ICC. But it was landmark that eventually led to the creation of the ICC, that I believe. Principles and customary rules applicable to individual criminal responsibility under international law was further crystallized through the 2 ad hoc tribunals that were created in the 1990s for the former Yugoslavia and Rwanda. which are called as the International Criminal Tribunal for the former Yugoslavia, or the ICTY, and the International Criminal Tribunal for Rwanda, or the ICTR, respectively. These two tribunals were established by the United Nations Security Council, and while similar with the ICC in some respects, they are different in others. At any stage of the procedure, the International Tribunal may formally request national courts to defer to the competence of the International Tribunal in accordance with the present statute and the rules of procedure and evidence of the International Tribunal. Accordingly, the ad hoc tribunals could assert primacy even when they are already domestic proceedings and request that the relevant individual to be transferred to the tribunal's custody. The architecture of the Rome Statute, however, took a very different approach. The ICC statute, or Rome Statute, recognizes that states have the first responsibility and the right to prosecute international crimes. The preamble to the statute emphasizes that the International Criminal Court established under the statute shall be complementary to national criminal jurisdiction. Article 1 of the statute also states that the International Criminal Court shall be a permanent institution and shall have the power to exercise its jurisdiction over persons for the most serious crimes of international concern and shall be complementary to national criminal jurisdiction. The relevant principle is therefore often referred to as the principle of complementarity. This means that the ICC may exercise jurisdiction only where national legal systems fail to do so, including where states are unwilling or unable to genuinely carry out proceedings. The principle of complementarity is based both on respect for the primacy jurisdiction of states and on considerations of efficiency and effectiveness, since states will generally have the best access to evidence and witnesses and the resources to carry out proceedings. Realistically, as a permanent international criminal tribunal with temporal jurisdiction that is significantly broader than its predecessor, it is impossible for the ICC to prosecute all cases of international crimes. Also, it is based on the principle that is a duty for the sovereign state parties to the Rome Statute to fight against the impunity. The Rome Statute does not specifically use the term complementarity, but the operation of the principle is embedded in several other provisions. Now, Article 17. Article 17, paragraph 1 of the statute stipulates that the court shall determine that the case is inadmissible where A, the case is being investigated or prosecuted by a state which has jurisdiction over it, unless the state is unwilling or unable genuinely to carry out the investigation or prosecution. B, the case has been investigated by a state which has jurisdiction over it, and the state has decided not to prosecute the person concerned unless the decision resulted from the unwillingness or inability of the state genuinely to prosecute. C, the person concerned has already been tried for conduct which is the subject of the complaint, and the trial by the court is not permitted under Article 20, paragraph 3, and D, the case is not sufficient gravity to justify further action by the court. The criteria for determining unwillingness in particular cases are set in the paragraph 2 of the same provision. This, again, clearly establishes that it is primarily for states to prosecute those allegedly responsible for committing core crimes. If a state and the ICC is interested in the same acts constituting alleged crimes, the ICC cannot proceed. Now, Article 18 of the Rome Statute, it will be related to my main theme for today. Article 18 of the statute gives effect to this principle. Under Article 18, the prosecutor is under an obligation to notify states which would normally exercise jurisdiction when it is found that there would be a reasonable basis for the ICC prosecutor to commence an investigation. Article 18, paragraph 2 states that within 1 month of receipt of that notification, a state may inform the court that it is investigating or has investigated its nationals or others within its jurisdiction with respect to criminal acts which may constitute crimes referred to in Article 5 and which relates to the information provided in the notification to states. At the request of that state, the prosecutor shall defer to the state's investigation of those persons unless the pretrial chamber on the applicable of the prosecutor decides to authorize the investigation. For your information, Article 5 stipulates crimes within the jurisdiction of the court, as already said, which mean core crimes. The crime of genocide, crimes against humanity, war crimes, the crime of aggression. The question still arises as to what extent to domestic proceedings need to mirror that before the ICC, for a state to be able to claim primacy. This has been subject to several litigations before the court. In instances where the prosecutor believed that there are no domestic proceedings mirroring those before the court, and the relevant state disagreed. Apart from the cases, this is particularly relevant for states such as Japan, which does not have domestic legislation incorporating crimes under the statute into domestic law. This necessarily means that any investigations and prosecutions carried out by such states will treat conduct amounting to core crimes as ordinary crimes. As you see on the slide, the question is, can state then be considered as fulfilling its responsibility to prosecute crimes under the statute, Rome Statute, by prosecuting them as ordinary crimes, and can such states successfully raise admissibility challenges? To address this question, today we will be looking into the appeals chamber's judgment in the Venezuela 1 situation, which was issued on 1st March 2024. Before we go into the substance, I will briefly explain the background of the case. Venezuela ratified the Rome Statute on 7 June 2000 and has since been a state party. On 27 September 2018, the officer of the Office of Prosecutor received a referral from a group of state parties to the Rome Statute regarding the situation in Venezuela since 12 February 2014. Article 13A of the Rome Statute stipulates that the court may exercise its jurisdiction if a situation is referred to the prosecutor by a state party. Accordingly, when there is a referral, the prosecutor can commence formal investigations without seeking judicial approval by the chamber. After a preliminary examination, the prosecutor concluded in November 2021 that he will proceed with the investigations. Pursuant to Article 18, Paragraph 1 of the statute, the prosecutor notified all state parties of his decision to initiate an investigation in the situation in Venezuela. As explained, upon receipt of the notification, states can request the court to defer its investigation. Indeed, on 16 April 2022, the prosecutor received from Venezuela a request for deferral of his investigation on the basis that Venezuela is investigating or has investigated its nationals with respect to alleged punishable acts. Subsequently, after exchanges between the prosecutor and Venezuela, he filed an application to the pretrial chamber requesting it to authorize the resumption of his investigation into the Venezuela situation. Pretrial Chamber 1 granted the prosecutor's request on 27 June 2023 and authorized him to resume the investigation. Venezuela appealed the decision before the appeals chamber, raising alleged errors by the pretrial chamber, several of which related to the principle of complementarity. The first issue that was raised in proceedings before the pretrial chamber was the issue of similarity between domestic proceedings and the ICC investigations. What the Venezuela's authority wanted to say, they themselves investigated and prosecuted the relevant crimes. The pretrial chamber stated that in order to satisfy complementarity principle, the domestic proceedings should also sufficiently mirror the content of the Article 18, Paragraph 1 notification. It went on to reject Venezuela's argument that the mere showing that on its face, domestic proceedings resemble to some extent the prosecution's intended investigation would suffice to discharge its onus that it is investigating the same. The pretrial chamber also found that under the sufficient mirror test, domestic investigations must substantially cover the same conduct and the same persons and groups. The sufficiently mirror test is a consistent standard and has been adopted by jurisprudence thus far. In the Philippines appeals judgment, the appeals chamber held that for the purpose of admissibility challenges under Article 18 of the statute, the state is required to demonstrate an advancing process of domestic investigations and prosecutions of the same groups or categories of individuals in relation to the relevant criminality, including the patterns and forms of criminality within the situation, which is a largely fact-driven inquiry. In the case of dispute, the prosecutor had notified Venezuela of his conclusion that there is a reasonable basis to believe that from at least April 2017 onwards, members of the state security forces and pro-government individuals committed the crimes against humanity of imprisonment or other severe deprivation of liberty, torture, rape, and other forms of sexual violence and persecution against civilians who are perceived or actual opponents of the government. Sorry, I omitted to show this slide, but I will go on. The appeals chamber found that accordingly, Venezuela was required to demonstrate an advancing process of domestic investigations and prosecutions, firstly, of the members of the state security forces and pro-government individuals, and secondly, in relation to the alleged patterns and forms of criminality, namely the crimes against humanity of imprisonment or other severe deprivation of liberty, torture, rape, and other forms of sexual violence and persecution committed against civilians who are perceived or actual opponents of the government. What is perhaps of greater importance for the purpose of this lecture is Venezuela's ground of appeal, that the pretrial chamber erred in finding that it was necessary for domestic investigations to cover contextual element of crimes against humanity. The contextual element of crimes against humanity means that an act must be committed as part of widespread and systematic attack against the civilian population for it to qualify as a crime against humanity. In the context of war crimes, on the contrary, the contextual element usually points to the nexus requirement with armed conflicts. Before the pretrial chamber, the prosecution argues that Venezuela has not investigated the possible systematic occurrence of the crimes against humanity and the existence of patterns and policies, instead characterizing them as ordinary crimes. Venezuela, on the other hand, denied that there were any crimes against humanity committed in its territory and stated that security forces made legitimate use of force proportionate to the violence of the situation in response to violent demonstrations by the citizens. It also claimed that any violations of citizens' rights were isolated and perpetrators were subject to domestic criminal law. Based on these submissions, the pretrial chamber considered that Venezuela admitted that it is not investigating the factual allegations underlying the contextual elements of crime against humanity. The appeals chamber ultimately sided with the pretrial chamber. In doing so, the appeal chamber made several important findings with broader implications. The appeal chamber firstly recalls that the prosecutor's Article 18 notification cited alleged crimes against humanity of imprisonment or other severe deprivation of physical liberty, torture, rape, and or other forms of sexual violence of comparable gravity and persecution under Article 7, paragraph 1 of the statute, committed by civilian authorities, members of the armed forces and pro-government individuals. Several requirements can be delineated specifically. 1. Underlying acts. 2. Attack directed against any civilian population. 3. Pursuant to or in furtherance of a state or organizational policy. 4. Widespread or systematic nature of attack. 5. Nexus between the individual act and the attack. And 6. Knowledge of the attack. The appeal chamber then stated, and I quote, "The appeal chamber recalls that the inclusion of the contextual elements as constitutive elements of the crimes allows for the identification of the legal interests protected by each provision, and that while war crimes give protection in criminal law to persons in times of armed conflict, crimes against humanity protect persons where there is a widespread and or systematic attack on a civilian population. Widespread or systematic attack directed against any civilian population is a hallmark as well as cross-cutting element of crimes against humanity. Therefore, in order to pursue the legal interests protected by crimes against humanity, a state which has not incorporated crimes against humanity in its domestic law, while not required to investigate the alleged crimes acts under the legal qualification of crimes against humanity, must nevertheless investigate the factual allegations underpinning the contextual elements of such crimes. This includes, in particular, an investigation into the factual allegation underpinning the widespread or systematic nature of the attack, and those that may allow the conclusion that the attack was carried out pursuant to a policy. Appeals chamber accordingly found that when the scope of the prosecutor's intended investigation, as set out in an Article 18, Paragraph 1 notification, includes allegations relating to crimes against humanity, a state seeking to assert its primary jurisdiction over such crimes must demonstrate the evidence, the existence of an advancing process of domestic investigations and prosecutions of the facts and circumstances underlying the alleged crimes, including the factual allegations in support of the aforementioned contextual elements of crimes against humanity. In the passage that I have mentioned, the appeal chamber makes a distinction between 1. Investigating criminal acts under the legal qualification of crimes against humanity, which is not required, and 2. Investigating factual allegations underpinning the contextual elements of alleged crimes against humanity, which is requested. This is consistent with the previous case law that holds that there is a distinction between acts and their legal qualification, and it is the former that matters. However, in my view, such a distinction is extremely difficult to sustain in practice. As a former domestic prosecutor in Japan, I can attest to the fact that criminal investigations at the domestic level are carried out in line with domestic legislation in light of the elements of crimes and the domestic criminal law. If there are no contextual elements under domestic criminal law, the investigating authorities will not and cannot investigate those facts. If you take the case of Japan, if there are individuals who have allegedly committed the war crime of internationally attacking civilians and murdered a lot of people, for example, abroad, in the context of an international armed conflict, who fled to Japan, the authorities of Japan would only be able to investigate the relevant person under the suspicion of murder. There is no room for them to investigate whether there was an armed conflict or if the nexus requirement is satisfied. As it is an ordinary murder, there will be no inquiry into the factual circumstances establishing the armed conflict. In such circumstances, there is a risk that any investigations conducted by Japanese authorities will be considered as not being similar to investigations before the ICC. So there will be a risk that ICC will determine that Japan did not fulfill the mandate of the complementarity under the Rome Statute. I am of the view that other parts of the Venezuela appeals judgment also shows that the focus in dealing with international crimes is towards a legal interest that it purports to protect, and not purely whether the underlying factual allegations were investigated. The issue that also arose in the Venezuela appeals was whether the pretrial chamber erred in requiring domestic investigations to cover discriminatory intent, which is a requirement for the crime against humanity of persecution. The appeals chamber rejected the argument raised by Venezuela. It found that the pretrial chamber correctly determined that the state was required to investigate facts underpinning discriminatory intent required for the crime against humanity of persecution, given that the element of discriminatory intent under the statute protects the distinct legal interest. The appeals chamber also rejected Venezuela's argument that possibility of addressing matters of discriminatory intent as an aggravating factor in sentencing. In doing so, the appeals chamber found, in my view, the statute are required to look into facts underpinning all elements of the crimes under the statute from the investigating stage and cannot defer consideration of such facts at a later stage. In relation to the sexual and gender-based crimes, the pretrial chamber took issue with the fact that some cases contain a reference to acts of rape as well as other acts that could qualify as sexual and gender-based crimes. But, I quote, the legal qualification and conviction do not include any crimes with a sexual or gender component in the Venezuela, in the Venezuela case. They were rather investigating in Venezuela's submissions as torture and cruel treatment. The pretrial chamber found that this was insufficient for it to consider that any investigation by Venezuela mirrored those conducted by the ICC prosecutor. The appeal chamber agreed with the outcome of the pretrial. It stated, with focusing again on the legal interest protected by each element, stating that the legal interest protected by each crime can be discerned by reference to the elements of that specific crime, and that the interests protected by materially distinct elements are necessarily different. Particularly in relation to sexual and gender-based crimes, the appeal chamber observed that different legal interests are protected by distinct elements of each crime, and that the distinction is even more significant between rape or any other form of sexual violence of comparative gravity and, for instance, the crime of torture. There are big gaps between the sexual violence and other crimes. Indeed, these crimes have materially distinct elements aimed at protecting different legal interests. Having noted this, appeal chamber went on to conclude that the pretrial chamber did not err by observing that the legal pre-qualification and conviction do not include any crimes with a sexual or gender component. Several things can be discerned from this finding. Most importantly, it is clear that the focus of the ICC inquiry in assessing whether domestic investigation mirror that of the ICC is not purely factual. The primary focus, rather, is whether domestic investigations and prosecution sufficiently address the legal interests that are covered by crimes under the Rome Statute. This is also clear from the appeal chamber's pronouncement that, and I quote, to the extent that Venezuela's investigations and prosecutions examined the relevant alleged acts as torture and cruel treatment, the domestic proceedings failed to address the distinctive legal interest protected by the crimes of rape and other forms of sexual violence as outlined above, and to protect the distinguishable harms suffered by victims. I believe that this reasoning is applicable to crimes other than rape or other forms of sexual violence. For example, Article 8, Paragraph 2, E4 prohibits intentionally attacking protected objects such as cultural property. The legal interests protected by this crime reflects the special status of religious, cultural, historical, and similar objects during armed conflicts. It is because of special status of protection that they enjoy. Their destruction is even more egregious. If states that have not incorporated core crimes into domestic legislation or to investigate such crimes, such acts, they may do so, treating them as ordinary crimes. But such an investigation would fail to properly capture the legal interests that the crime actually entails. The same is true for other crimes, such as the crime against humanity or persecution. As was discussed in the Venezuela appeals judgment already, states would need to look into discriminatory intent, as well as the specific nature of the crime, which is that it covers a group of people who are targeted for their shared characteristics. Treating individual victims distinctly as individual victims of ordinary crimes would not sufficiently capture the legal interest that the crime against humanity or persecution purports to protect. However, as mentioned earlier, it is in practice impossible for domestic authorities to investigate matters outside the elements of crimes under domestic criminal law. I have referred to the existence of several ad hoc tribunals at the beginning of this lecture, amongst which was the ICTY, or the International Criminal Tribunal for the former Yugoslavia. If we look at Article 10, Paragraph 2 of the ICTY statute, it stipulates that a person who has been tried by a national court for acts constituting serious violations of international humanitarian law may be subsequently tried by the ICTY only if, 1, such proceedings were not impartial or independent, or 2, if the act for which the person was tried was characterized as an ordinary crime. This principle already demonstrated an understanding that investigations and prosecutions carried out treating something as an ordinary crime cannot be considered an effective prosecution of international crimes. Similarly, the draft article of the Prevention and Punishment of Crime Against Humanity, adopted by International Law Commission, has a dedicated article to the criminalization under national law. It would be a very important next treaty in a few years, I believe. It stipulates that each state shall take the necessary measures to ensure that crime against humanity constitute offenses under its criminal law, and also inter alia that the offenses constituting crimes against humanity should not be subject to any statute of limitations. As we have seen from the relevant part of the Venezuela appeals judgment, it is clear that international criminal law has moved towards requiring states to investigate all elements of crimes under the statute, I mean the Rome Statute, and not just the elements under domestic law. This poses a particular challenge where the domestic law does not mirror the Rome Statute and does not incorporate international crimes as such. In the Venezuela appeal, the state argued that statute does not impose any obligation to incorporate crimes against humanity into domestic legislation. The appeal chamber responded by recalling that the statute stipulates that an effective prosecution of the most serious crimes of concern to the international community as a whole must be ensured by taking measures at the national level. The preamble also imposes on every state the duty to exercise its criminal jurisdiction over those responsible for international crimes. Therefore, the appeals chamber opined that while the statute does not expressly impose an obligation on state parties to incorporate crimes against humanity into their domestic legislation, such incorporation may facilitate the fulfillment of their duty to exercise criminal jurisdiction over those responsible for international crimes, and that state parties are encouraged to transpose the statute into their domestic legislation. I am in agreement with this view. I believe that in order for states to properly discharge its obligations under the Rome Statute, they must enact legislation incorporating crimes into the domestic legal system. The reality is that not all states, including Japan, have done so. However, you are now aware that this raises certain legal issues and could risk the court finding that the state is not conducting investigations that sufficiently mirror the ICC's. I therefore hope that you will give these issues some thought and discuss this with your colleagues upon return to your home country. Thank you very much for your attention, and I would be happy to take any questions you may have related or not related to my lecture. but related to the ICC, of course. Any questions you may have? For the remainder of the lecture. But please understand, as a judge of the ICC, I cannot comment on matters that are still pending before the court or may come before the court in the future. And also, I cannot reply to you on the questions politically motivated. Thank you.